Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is the first time we are going to deal with the leading case. So, it is our regular practice that we recite preamble of the Constitution before we start with the topic. So, I request each one of you to recite preamble along with me because we strongly believe that preamble our goal and preamble our soul. So, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Deals with the important case laws, newly added case, serial number 85, Property Owners Association and others versus State of Maharashtra and others. Property Owners Association and others versus State of Maharashtra. SCR citation is 2024 11 SCR Supreme Court report, page number 1. An equivalent citation in other journals, they have included 2024 SCC Online Supreme Court, page number 3122. This is one of the leading cases, dear friends. Landmark summaries are available in the website, and even it is available in Supreme Court Chronicle also, that magazine also it is available. But still, apart from that, what we are going to tell you, please make a note, or from the video you please make a note. I think this will be to some extent self-sufficient, and if you want to read it in detail, always the entire judgments are available. Now, what is the issue? Let us apply this test, dear friends. I told you just now the facts of the case. Let us ask, what is the facts? What does it say? Property Owners Association versus State of Maharashtra. So this case arising out of the Maharashtra, Bombay High Court. And who has filed it? Property Owners Association. So there is a problem for the property owners. So let us ask, what is their problem? Right? So their problem is they have challenged Chapter 8A of the Maharashtra Housing and Area Development Act 1976. I repeat, Maharashtra Housing and Area Development Act 1976. Why they have challenged? What is the problem with Chapter 8A of this Act, Maharashtra Act? Basically, the problem in Bombay buildings are, it is a coastal area. That saline air mixes and it damages the properties. If normally such building in Delhi, if the lifespan of that building is 100 years, there it is only 60 years. I'm just giving you an example. Because of the weather, because of the air, and it is densely populated area also. And some of the people, poor people, they live in a dilapidated condition house. They don't have money to repair also. Tenant is there. Tenant will tell to the owner, repair it. Owner will say, you are there, you repair it. When case is pending before the rent controller, meanwhile disaster happens, the entire building collapses. And who is liable now? Both the owners and tenants have gone. The entire building goes. So this is the major problem, dear friends. So what is the object of this chapter 8A? Chapter 8A, Maharashtra, state of Maharashtra has come out with the amendment to this act by inserting chapter 8A that we will sort out all the dilapidated buildings. We will repair it. We will acquire it. We will repair it. If it is beyond the repair, we will reconstruct it and give it to the people who are needy people. What about the owner? We will compensate. 100 times we will compensate. What is the rent? As of now, 100 times multiplied with that, we will compensate. No difficulty. But landowners, they have certain sentiments towards their property. So they filed a writ petition before the Honorable High Court. Before the Honorable High Court, the submissions of the Landowners Association was, we have a property. Right to property is a constitutional right guaranteed under 300 capital A. And Article 14 provides us that no state should act in an arbitrary way. You cannot take away my property and you cannot give it to someone that he is a needy person. How can you take away my property? That was their submission. But the state of Maharashtra has made a submission. There is a directive principles of state policy section Article 39B, which says that they can take away the resource. I will be reading that material resource of the community. The particular term is material resource of the community. So even if you are owning, it is private land, but it can be acquired for the public good. That is what Article 39B says. So we have come out with this chapter 8A in order to give effect to 39B of Constitution of India, to serve the public, because to prevent concentration of wealth in few hands. So that was their submission. And they took the protection from Article 31 capital C. What does it say, Article 31 capital C? It cannot be challenged, though that particular act or chapter 8A violates Article 14 or 19, still it can be protected if such law gives effect to Article 39B. Because 31C reads like notwithstanding anything, notwithstanding what is stated in Article 13. Article 13 says that anything inconsistent with the fundamental rights, it can be struck down. That is the general rule. The exception is 31 capital C. Why? Because to give effect to directive principles of state policy. So based on these arguments, writ petition was dismissed by the High Court. Now who is aggrieved? Owners are aggrieved. They come before the Supreme Court. Now the matter referred to the 9 judges bench. Why the matter was referred to the 9 judges bench? Because it required certain interpretations, because the earlier judgments were interpreted, and one of the judgments was Maffatlal case, where 9 judges sat. So therefore it required the reconsideration. Therefore they had a combination of 9 judges. So I will be telling you what was the issue before the Honorable Supreme Court. Now facts is clear. Now let us move on to the issues. Issue is at page 140, dear friends. The issue before the Honorable Supreme Court was 2. In view of the above, the scope of this judgment can be tied down to determining 2 issues. Firstly, Article 31 capital C. Whether Article 31 capital C, as upheld in Keshavananda Bharati, survives in the Constitution after the amendment to the provision by the 42nd amendment was struck down by this court in Minerva Mills. See, dear friends, though we are reading Property Owners Association, they are referring to Keshavananda Bharati case, that is also a leading case. They are referring to Minerva Mills case, that is also a leading case. So while reading this judgment, we can bring them, those cases, under one family. Keshavananda Bharati, Minerva Mills, Property Owners Association can be brought under one family. And what they are saying is, this Article 31C was challenged. Constitutional validity of 31C was challenged in Keshavananda Bharati's case. In Keshavananda Bharati, 13 judges has held that it is constitutionally valid. 31C is constitutionally valid. Thereafter, in Minerva Mills case, there was a 42nd amendment. The issue before the Minerva Mills case was whether a law can be made to give effect to the directive principles of state policy overriding fundamental rights. Fundamental rights is enforceable. Directive principles of state policy is not enforceable. So can we give primacy to directive principle of state policy over fundamental rights? To that extent, they have struck down the amendment as null and void. So now what is the effect? 31C is prevailing. Amendment to 31C was struck down in Minerva Mills case. So what was the position of Article 31C at the time of Keshavananda Bharati? Still holding the field. So that principle will be applied here. Now you see the question. Article 31 capital C, whether Article 31C as upheld in Keshavananda Bharati survives in the constitution after the amendment to the provision by the 42nd amendment was struck down by Minerva Mills case. So when there was amendment 42nd amendment which was struck down by Minerva Mills, what is the effect? That is the question. The second question is Article 39B, whether the interpretation of Article 39B adopted by Justice Krishna Iyer in Ranganatha Reddy and followed, see, in Ranganatha Reddy case is there, where Honorable Justice Iyer has said material resource of the community means even private property can be owned by the state. So that was held by Justice Iyer, Krishna Iyer. Same was followed in Sanjeev Coke case. There is yet another case. Sanjeev Coke must be reconsidered. Whether the phrase material resources of the community in Article 39B can be interpreted to include resources that are owned privately and not by the state. So now the question is whether Article 39B, whether does it cover material resource of the community means does it cover the privately owned property also or not? Because these property owners are affected. These are the two interpretations, dear friends. Two issues came up for the larger bench. The larger bench has considered this, gave a finding, gave an authoritative pronouncement, and then they have referred the matter to the honorable judge to constitute a regular bench to hear on the basis of the principles laid down. Law laid down by the Honorable Supreme Court in this leading case will be a guiding light for the regular bench to decide the matter. Now what they have held, let me read for you, dear friends. So we have seen the questions also, questions for determination. Now what is the reason? Reason given by the Honorable Supreme Court is, before going to the decision, dear friends, what was involved? Interpretation. Article 31C, in which they have discussed about the brief history of Article 31C. Then the present dispute concerning 31C and rival contentions, precedents concerning invalidation of amendments. This is important. Analysis and conclusions concerning Article 31C. So which page, dear friends? This is at page 167. Please note down these pages. Yes. Para 71. With respect to 31 capital C is concerned. The final question is whether revival of the unamended text of Article 31C would in some way manifestly contravene the principles laid down in the judgment of Minerva Mills or result in some other adverse consequence. The text of the unamended Article 31C was challenged, and the first part of the article was upheld by 13 judge decision in Keshavananda Bharati, while the later half of the article was invalidated. Therefore, the first half of the unamended Article 31C, which is the subject matter of the present controversy, was undoubtedly constitutional. They are saying it is constitutional, as held by 13 judge decision in Keshavananda Bharati and further by the Constitution bench in Vaman Rao. So they have concluded by saying, by holding that, we conclude that the unamended Article 31 capital C continues in force. Therefore, Article 31C is not invalidated by Minerva Mills. It is continued to be in force as held in the Keshavananda Bharati case. So, meaning thereby, let me take it forward. Chapter 8A of the Maharashtra Act can be saved by invoking Article 31C because it is still holding the field. Ultimately, we have to apply and then take it to our case. Right? Now, let us move on to interpretation of 39B. Whether material resource of the community, does it include the private also or not, private properties or not? For that purpose, dear friends, the Honorable Supreme Court has discussed beautifully the beauty of art of writing judgment. We have to learn from Honorable former Chief Justice Honorable D.Y. Chandrachud. My Lord has written, see, it is though it is running to several pages, all the headings are given. So by reading this itself, you will understand the entire aspect of the case. So this is what we generally ask you also to write synopsis in a detailed judgments. Therefore, the examiner will understand how we are going to deal with. For interpreting 39B, they have recorded under the heading submissions. Submissions of the appellants and interveners. Submissions of the respondents and the interveners. Submissions are over. Now, the second is judicial discipline. See, doctrine of judicial discipline has come. Observations in Sanjeev Coke and Muffet Law. The resurrection of the minority view in Ranganatha Reddy by Sanjeev Coke. In Ranganatha Reddy, there was a minority view by Honorable Justice Krishna Iyer. Resurrection means what? Reviving, coming from a dead, taking birth from the dead. Already a person is dead. Minority view is not holding the law. But it is resurrection of the minority view in Ranganatha Reddy by Sanjeev Coke. In Sanjeev Coke case, the honorable judges refer to the minority view, which was not the law at all. They have, therefore, those dead letters has brought as a live one by Sanjeev Coke case. This is number one. Next is Sanjeev Coke erred, committed mistake in relying on the observations of the minority in Ranganatha Reddy. Third aspect is the error has been carried forward in subsequent decisions. Number 4, the single line observation in Muffet Law is not a ratio decidendi, is only obedient dicta. In Muffet Law case, there is a stray observation which says that private property will also fall under the material resource of the community. So it is not a ratio decidendi, it is only the obedient dicta. After reading all this, after going through everything, there is interpreting Article 39B. How they are interpreting? See, Article 39B as a prerequisite to protection under Article 31C. When a law is made in order to give effect to 39B, that has to fulfill through 31C. 31C will protect it. So, Article 39B as a prerequisite to protection under 31C. If you are claiming a protection under 31C because it is going to violate 14 and 19 of the Owners Association, if it is going to violate, how are you going to take the protection? Protection you will be seeking under 31C by fulfilling the conditions that it is going to satisfy the directive principles. So, give me a second, dear friends. Article 39B as a prerequisite to protection under Article 31C. When you want to invoke 31C, you need to fulfill the conditions provided under 39B. Article 39B is a directive principle, and the lordships have taken pain to quote historical context, constituent assembly debates, debates about the purpose of directive principles, debates about the text of Article 39B, inferences from the discussions in the Constituent Assembly. Now, interpretation of Article 39B that has been doubted. Correctness of the above interpretation of Article 39B. The interpretation is inconsistent with the text of Article 39B. The interpretation amounts to endorsing a particular economic ideology. The interpretation, because the Honorable Supreme Court is giving a finding with respect to the minority view held by Honorable Justice Krishna Iyer in Ranganatha Reddy's case. So, what they are saying is the interpretation is inconsistent with the text of Article 39B. The interpretation of Honorable Justice Krishna Iyer amounts to endorsing a particular economic ideology. The interpretation is incompatible with the right to property, determining the materiality and community element as the resource. The provisions may include the vesting of private resources in the state. And ultimately, what is the conclusion, dear friends? The conclusion is at page 223. And it is comprising of 9 judges bench, 7:2. 7 judges majority. Majority judgment was authored by Honorable Chief Justice of India, former Chief Justice of India, my Lord, Dr. D.Y. Chandrachud. Minority view, partly agreeing, partly dissenting by Honorable Ladyship Justice Naharatna and Honorable Justice Dulia. His Lordship has completely dissented and travelled along with my Lord Justice Krishna Iyer. Now today is the majority view we will be seeing. We will be seeing in future classes, upcoming classes, the minority view also. Now let us move on to the conclusion, dear friends. This is at page 223. Yes. Because the reference was with reference to the correctness of the interpretation of 39B in Ranganatha Reddy's case. Thereafter, Moffat Lal case, everything is given. Co-case. Conclusion is, in a nutshell, the answers arrived by this court to the reference before us may be summarized in the following terms. This is what ultimately in a tree means you are expecting the fruit. The fruit of this entire judgment is this, dear friends. A. Article 31 capital C, to the extent that it was upheld in Keshavananda Bharati versus Union of India, remains in force. So what was upheld in Keshavananda Bharati's case with respect to Article 31 capital C remains in force. Number 1. Number 2. The majority judgments in Ranganatha Reddy expressly distance itself from the observations made by Justice Krishna Iyer, because it was only the minority view by Justice Krishna Iyer. So majority, they have distanced themselves from the minority view. Speaking on behalf of minority of judges on the interpretation of Article 39B, thus a co-equal bench of this court in Sanjeev Kok erred, committed mistake by relying on the minority opinion. How in Sanjeev Kok case, how the honorable judges can rely upon the minority view by leaving the majority view? So therefore they have committed a mistake. That is against the doctrine of judicial discipline. Number third, the single sentence observation. Dear friends, this is very important. What is the difference between ratio decidendi and obiter dicta? The answer is here. The single reference, single sentence observation in Muffat law to the effect that material resources of the community include privately owned resources is not part of the ratio decidendi of the judgment. Thus, it is not binding on this court. Therefore, it is only obiter dicta. It is not a reason to the decision. Therefore, it is not binding means it will not fall under Article 141 of the Constitution. D. The derived question referred to this bench is whether, this is second point, dear friend, 31C is answered. Now, how to interpret 39B? The derived question referred to this bench is whether the phrase material resources of the community used in Article 39 Clause B includes privately owned resources. That is the question. Whether privately owned properties can fall within the ambit of material resources of the community. That is the question. What is the answer? The answer is theoretically, the answer is yes. Privately owned property also will fall under the material resources of the community. For theoretical purpose, the answer is yes. Now, what next? Theoretically, the answer is yes. The phrase may include privately owned resources. That means what? Privately owned property also can be acquired by the state. However, there is an exception. Good for lawyers. Whether will it fall under the exception clause or for the general category, it is up to us to interpret. However, there is an exception to it. This court is unable to subscribe to the expansive view adopted in the minority judgment authored by Justice Krishna Iyer in Ranganatha Reddy and subsequently relied on by this court in Sanjeev Kok. The exception is, not every resource owned by an individual can be considered a material resource of the community merely because it meets the qualifier of material needs. The inquiry about, now they have said all private properties will fall under the material resource of the community. The exception is, what is the exception? This is what the exception. We have to ask ourselves whether will it fall under this general category or not. We have to ask these questions. The inquiry about whether the resources in question falls within the ambit of 39 Clause B of the Constitution must be context specific and subject to a non-exhaustive list of factors such as, what are those exceptional factors? Nature of resource and its characteristics. Number one, the impact of the resource on the well-being of the community. Impact of the resource on the well-being of the community. Number three, scarcity of the resource and consequence of such a resource being concentrated in the hands of private players. The public trust doctrine. What is public trust doctrine? State government is considered to be a trustee of the natural resources. Water, air, can we claim it? State is the owner. State is the trustee. And what is the duty? It is an obligation on part of the state is to prevent the misuse of those natural resources. They should prevent if there is an exploitation for private gain by private players. So that is also a test. The public trust doctrine evolved by this court. may also help to identify resources which fall within the ambit of the phrase material resource of the community. Last but not the least, dear friends, the term distribution has a wide connotation. The various forms of distribution which can be adopted by the state cannot be exhaustively detailed. However, it may include the vesting of the concerned resources in the state or nationalization. In the specific case, the court must determine, in the specific case, the court must determine whether the distribution subserves the common good. The last para is the reference is answered in the above terms. The registry is directed to obtain administrative instructions from the Chief Justice for placing the matters before an appropriate bench. So when there was a confusion by the regular bench, we referred the matter to the larger bench for authoritative pronouncement. So in this, what is the authoritative pronouncement? 31 capital C is valid as held in the Keshavananda Bharati case. To what extent it is valid as held in Keshavananda Bharati case still holds the field, number one. Number two, interpretation of 39B of the Constitution of India. Whether material resource of the community includes the private property, theoretically the answer is yes. But if you are going to include, you have to ask these questions. What is the nature of the resource? Whether there is a scarcity, whether public trust doctrine can be applied, and it has to be very specific. You cannot take away somebody's property and then say it falls within the material resource of the community. These tests has to be asked before you acquire those properties and make the private properties to fall within the ambit of 39B, dear friends. So this is only the majority view. So we will have the minority view in the upcoming sessions, and we will take up the remaining cases in the upcoming lecture series, dear friends. Thank you so much for your patience hearing. Please watch this video multiple times and make notes with reference to the detailed judgment. So thank you so much, dear friends, for your patience hearing. Greatly obliged.